Hey, hopefully everyone can hear me. Welcome. Thank you for joining us for today's webinar with Harry Margolis while he reviews elder law cases from the last year. My name is Beth Cohen-King, and I'm the Marketing Director at Margolis, Bloom & D'Agostino. So the reason for this webinar is because it's important to know what's happened in the courts in the last year. Some of these situations might be applicable, as well as thinking about some of the pitfalls and what to avoid if you run into any of these situations. As we know, family and MassHealth can be messy. We do have a panel on the side of the screen that you can use to type in questions. You should see it, it says question, it's a question panel. I will try to interrupt Harry if something's relevant and can go into the presentation. There are a lot of cases today, so we'll see what we have time for. And for some reason, if you do need to jump off, no worries, we are recording the presentation. So with that, let's begin.
Okay, thank you, Beth. Hello, everybody. We've got 45 minutes to go through 14 cases, which are listed here. And we'll see if we make it. There are a couple cases I realize that were decided a little more than a year ago, so kind of outside of our focus area, and they were actually non-mass cases. So if we have time, we'll get to those as well because they're kind of interesting. But if not, those are the ones I'm going to drop off. So so here we go. So the first case is Aflac versus Joanne Parker, and this has to do with an insurance policy, and and basically who should get it and what happens when you get divorced. So Sean Parker bought a $100,000 life insurance policy in 2010 for the benefit of his wife Dawn. They got divorced in 2016. He died in 2018. And so the question is, does Dawn get the benefit, that $100,000 benefit, because she's named as the beneficiary, or does his mother, who's his heir, under I think he was intestate, so under the rules of intestacy, and so under the common law, basically the rules changed. So under the common law, divorce did not affect beneficiary designation. So Dawn would have gotten the policy, but Massachusetts adopted the Uniform Probate Code in 2012, which reversed the common law on this. And so now divorce does revoke the beneficiary designation. As a result, in this case, the policy went to Joanne, the mother. And so one question is kind of all the timing of this. So Dawn argued that the rules should not apply retroactively, and the court said, yeah, it does apply because Sean always had the ability to change the beneficiary designations. She also argued that she and Sean had an oral agreement concerning the policy, and that the court didn't give it much weight to that, in large part because they had a written separation agreement. The separation agreement says this is comprehensive, this covers everything, so it would supersede any oral agreement. So what appears to have happened in this case is that when they got divorced, Sean and Dawn just went to the probate court, got a probate court form, filled it out, and it didn't say anything about the insurance policy. And hopefully if they had a lawyer, they would have asked questions like, do you have an insurance policy, and had decided where that would go, and maybe Dawn would have gotten that as part of the separation. But without it, she was out of luck without that being included in the agreement. And I figure there's a couple different morals to this story. One, get a lawyer if you can afford one. Two, don't get married, because interestingly, it was the divorce that canceled the beneficiary designation. If they were never married and just separated and the beneficiary designation was still there, the money would have gone to Dawn. So Next case, and actually a couple of cases on this issue, has to do with the statute of limitations and whether a challenge to a trust or a will be subject to a 1-year statute of limitations after death to bring the action, or a 3-year statute of limitations, which is the normal statute for torts. And what it turns out is it depends on the kind of what are the terms of the case. So what are you going after? So this is a sad case. Jeffrey Sachs died of a brain tumor in 2012, and he had decided to forego treatment. And his mother was already had a stroke, and she was having some dementia, and she disagreed with her son's decision to forego treatment, and blamed her grandson and 2 of her daughters for her son's decision. And the 2 other daughters convinced her husband Aaron to disinherit Jeffrey's children, because they blamed Jeffrey's children for going along, or maybe they think, or maybe she thought, convincing Jeffrey to forego treatment. So Aaron did that. He changed his estate plan, amended it so that nothing went to Matthew and Rebecca. And the trust provided, Aaron's trust provided, it was for Sheila's benefit during her life, and then it would be for, then it would pass to their children, but not to the grandchildren, not to Jeffrey's children. So Sheila died in 2019, and Matthew and Rebecca sued, challenging the trust amendment. The trial court ruled against her, saying that the, a little distracted, someone just came to my door. So the trial court ruled against Matthew and Rebecca, saying that they were subject to the 1-year statute of limitations on challenges to wills or trust. And the SJC disagrees here. It says this is not a case, this is not questioning the validity of the document. Instead, this is a claim for intentional infliction, intentional interference with an expectancy. So this is really a claim against the Matthew and Rebecca's aunts, who had apparently egged Sheila on to convince Aaron to change his will, and that claim has a 3-year statute of limitations. Now, of course, Aaron changed his will long before 2019, more than 3 years before that, but they were allowed, I guess, not exactly sure why, now that I'm thinking about it, why the 3 years still was in there, going back this so far. Let me look back at the dates here. Not sure when Aaron changed his will, but anyways, apparently they were in the 3-year statute, and I apologize for not being clear on that. And one thing the court said that I thought was really interesting is this is not a claim that the trust was invalid, which would have been subject to a 1-year statute, because if the trust were, because it was only because the trust amendment was valid that they had a claim for intentional infliction or intentional interference with an expectancy. So, and so the court also distinguishes between trusts and wills, because in a trust, you don't get the same kind of notice as in a will. So that's probably why they still have the 3-year, they're still within the 3 years, because they didn't necessarily know what was going on with the trust until after Sheila died. Not, I mean, if this had been in Aaron's will, they would have gotten notice and had a year to challenge it. But since this was a trust and they didn't really know anything until 2019, they could still challenge things this so many years later. So that's basically just to summarize, and I don't think I was too clear in my presentation, is if you're challenging the validity of the document, you have a 1-year statute of limitations. But if your claim is for a tort, you have 3 years. And then when does the 3 years start running? And if it involves a will, you still have, since you got notice, you have shorter time than with a trust, because you get notice later for that. And this is related to the next case, Collecchio Family Irrevocable Trust, which has a similar situation. Again, it's sort of a split decision. So in 2005, Lillian Collecchio transferred her family home in Revere to an irrevocable trust. And she had 6 children, 3 sons and 3 daughters. And she said that she basically favored the daughters. So she said that each of the sons would get 10% of the value of the house when it's sold, and the other 70% would be divided between her 3 sisters. One of her sons, Michael, continued to maintain the house, and when he found out in 2016 what the trust said, because he had never known about it, he got pissed off, and he said, "I've done all this work maintaining the house. I should be paid for that." And he sued on a number of grounds. So under quantum merit for his work, he said he should have received notice about the trust long before his mother's death, so he wouldn't have known about it. And then he claimed that Lillian was induced to create this trust by undue influence. So the court has a kind of a mixed decision here. So on the claim for services, it says Michael's out of luck because he's basically suing the wrong party. So under the terms of the trust, Lillian was still responsible for maintenance of the house, and so if he has a claim for services, it's against her estate. And as I understood it from the decision, the only thing in her estate was the house, which was in the trust. So he's out of luck there. And then they said he wasn't entitled to notice about the trust because he was not a qualified beneficiary. And this is under the Uniform Trust Act, which distinguishes between qualified and unqualified beneficiaries. And qualified beneficiaries are those who have a current right to receive distributions. And so the way the court interprets the UTC is that Michael had no right to notice until his mother's death, because until then he had no right to a distribution. So he was not a qualified beneficiary. However, as with the Sachs case, his claim for undue influence still stands. So he can still pursue his claim basically against his sisters for unduly influencing his mother. Now, the problem with this case is there's not a whole lot at stake. So the house sold for $366,000. Under the trust, Michael was entitled to a 10%, so a little over $36,000, assuming there were no expenses or attorney's fees. So if he wins the case and he's entitled to a sixth of the house value, that would bring his share up to 61%. So there's a difference of about $24,000 between what he was getting and what he felt he should have gotten. I'm sure the legal fees were a lot more than that, but that's often in court. People are swayed more by their feelings and by their more by their feelings and their wish to be proven right than by the economics. But I think part of the problem with this, I mean, a lot of these cases is there's just a lack of transparency. Because I'm sure Lillian did not tell Michael and his brothers that she wasn't giving them a bigger percentage of the house because she didn't want to create a lot of trouble. But if everybody had known and she'd explained why she was doing it, Michael then could have said, okay, well, you're on your own and taking care of the house, but there might not have been this family feud. So I'm a proponent of transparency. So here's another case involving a house, and it's a question of domicile, and it's an issue of domicile in a bankruptcy case, and basically for a homestead declaration. But I think some of what it says applies to other situations. For instance, if you were to move out of state to avoid the Massachusetts state tax, what would be the standard? So in this case, Andrea and Jera, who's a man, filed for bankruptcy, and he owned a house in Martha's Vineyard, and he had a homestead exemption on the house. And you're only entitled to a homestead exemption on your home. And that's the question here is, was this house his home? So, so he bought this house in 1992. He didn't move into it until 2005, but then he kept moving around. It sounded like a lot of this was for work. So he lived on the vineyard for a while in Connecticut and in Maine. But all this time, he maintained a Massachusetts driver's license. He was registered to vote in Edgartown and voted there a number of years. And the court found in his favor that he hadn't established a domicile anywhere else. So he, sorry, might need to get a cough drop. He hadn't established a domicile anywhere else, so he stayed. So this house continued to be his domicile. And so he won. And on appeal, the First Circuit Court basically said, you can look at it either way, but we're gonna go with the bankruptcy court, because they were basically, there isn't enough evidence to overturn it. It's a permissible view of the evidence, as they put it. And unless, and I said it was the First Circuit, I think that was a mistake. It was actually a district court review of the bankruptcy court. And they said that this was a permissible view of the evidence, and unless they were strongly convinced that there had been a mistake, they're not going to overturn it. So I think that the conclusion and the moral of the story, as I said, is domicile is sticky, and you must show an intent to change it in order to establish a new domicile. Okay, so now we're going to start getting into a few MassHealth cases. And this is a MassHealth case sort of kind of on the side. The issue is whether or not a deed may be reformed. So in 2008, and the question, they wanted to be reformed to avoid MassHealth estate recovery, and MassHealth objected. So in 2008, Athena and Soterios Koutoukis signed a deed intending to create a life estate, but it had, and basically giving a remainder interest to their daughters and keeping a life estate for themselves. But the language was a little funny because it said it gave the home to their daughters as tenants in common for life and further. So it's only giving it to them for their lives. The remainder is basically that Athena and Soterios were supposed to keep it for their lives, not Marina and Joanna. And in addition and further, it's not even clear what that means. So so after, I forget which of the spouses was a survivor, but after the survivor died, MassHealth made a claim for $74,000, and the probate attorney sought to reform the deed to make it clear that it's a clear life estate, and there was no MassHealth's claim can't survive because the house was passing directly to the daughters. And the drafting attorney acknowledged his mistake, and MassHealth objected on a couple grounds. First, I mean, it's claimed that the deed was fine. It said that Sartorius's will gave everything to Athena, so that showed his intent to give the house to her as well, not to the daughters. And the life estate also had a power of appointment in it, and they argued that that brought the property back into Sartorius's estate. And the court objected. The court allowed the reform because it said wills often have to give say who gets property, and there can be beneficiary designations on in trusts, in IRAs, in bank accounts, investment accounts that are different from the will. So what the will says is basically irrelevant. The power of appointment was limited in the deed. It was only allowed, he was only allowed to appoint to issue. So the fact that he had a power of appointment did not bring the property back into his estate. And so it seemed that MassHealth was basically objecting because it wanted to object to get the money, but not, it didn't seem to have any legal grounds for its objection to the reformation. So you can fix things after the fact, which I guess. So before we get back to the other MassHealth cases, these are kind of doing these more or less in reverse chronological order. There's an interesting conservator case. So this involves a lawyer, Sherilyn Richard, who became a conservator for Kathleen Hornibrook, who suffered from dementia. And she became the conservator, but Kathleen's son, Kevin, became her guardian. And it was a difficult case. There was dementia, there wasn't much money. And but the other difficulty was there was another son, Francis, who lived with Kathleen and interfered with home care aides. So so Kathleen moved to a nursing home, and Kevin had this whole plan for how Kathleen could move back, that they would evict Francis, they'd rent out 2 apartments in the building to generate income, and then they would have a sufficient, they would have a place where Kathleen could be without Francis there, and they would have sufficient income to pay for the home health aides. But in Kevin's view, Sherilyn didn't move fast enough to make all this happen. And while she wasn't acting, there was a reverse mortgage lender who brought a foreclosure action since Kathleen was no longer in the house. And so Sherilyn Richard ultimately evicted Francis, prevented the foreclosure, got a license from the court to sell the house, which he did. And Kevin was upset, and he brought this action against her for breach of fiduciary duty, malpractice, conversion, and fraud. The Superior Court dismissed most of the claims, but on a couple of them, the breach of fiduciary duty and conversion, they allowed discovery to proceed, basically saying they thought the claims were paper thin, and saying that the conservator enjoys quasi-judicial immunity when acting within the scope of his or her duties, but they permitted discovery to proceed, and both parties appealed to the SJC. And to be honest, I find this decision confusing. So the SJC holds that a conservator is a non-judicial person fulfilling quasi-judicial functions, and therefore the conservator shares in the judge's absolute immunity. So that would first mean to say, okay, the conservator is protected. And they says it's important that a judge and those acting in quasi-judicial capacity be able to act freely without the threat of lawsuit. So that's good. But then it says, well, was Attorney Richard acting within the scope of her duties? And they said she was. But then they said, well, she was because she got the license to sell. So then it seems, so are you always, as a conservator, have this immunity? or do you only have the immunity if you get explicit court approval, and then you're just carrying out what the court has told you you could do? And Kevin argued that she should not get this judicial immunity, even though she did have a license, because she only had to get the license because she screwed up and didn't put things in place to allow Kathleen to return home before she had to sell the property. And the SJC says no, that prior action is covered by the license because in her petition for the license, she explained the whole history of what had happened. So as I say here, I'm confused. So the SEC seems to grant quasi-judicial immunity in one hand, saying conservators should enjoy it. On the other, they're saying they can only enjoy it if they get a license, if they get court approval. So I think the bottom line is, if you're a conservator or a guardian and you think anyone's going to challenge what you're going to do, you should get court approval. Otherwise, you may be on your own defending your action. Okay, back to MassHealth. So the Fournier case is the final death blow, we hope, to MassHealth's challenges to powers of attorney, powers of attorneys, and powers of appointments in irrevocable trusts. So this trust in question had a power of appointment, power of attorney here, power of appointment to charity. And a lot of trusts have this, and the reason trusts might include this is one way to be sure that you will get if you have a house and it's in the trust and you sell it, that the sale will qualify for the $250,000 exclusion on capital gains on the sale of your home. So if it's a grant or trust as to income, and this is one way to make the trust that way, or I guess as to income or to principal, then you can take that exclusion. And so MassHealth said, well, she's got this power of appointment, so that the Emily, I'm trying to pronounce her name, Meziasek, went to a nursing home, and she had this power of appointment, and MassHealth said, well, this is an accountable asset because she could appoint the property to a charity that runs a nursing home in exchange for the nursing home care. So that's their argument. And so Ms. Yasek appealed the MassHealth opinion to Superior Court. She won, and MassHealth appealed to the SJC. And MassHealth had left this question open in the seminal case of Daly versus MassHealth, and here finally closes that door, and it says MassHealth's argument is not permitted under established principles of trust and property law. So basically, she's allowed to make a charitable donation with her power of appointment, but she's not allowed to make a charitable donation in exchange for a benefit that she's going to receive. That would violate the terms of the trust. So MassHealth loses. It's not a accountable asset, and people can who have trusts like this, and there are a lot of them out there, can proceed with a lot more comfort than they had before this. And I think we have Lisa Neely of Merrick-O'Connell, who's the attorney who litigated this, to thank for this, and she's really been the leader of litigation on MassHealth trust cases. So thank you, Lisa. So MassHealth lost on the trust case, and we hope maybe they'll stop challenging all these trusts in the future, but they won an annuity case. So as you may know, annuities are often used when there's a husband and wife, when one spouse goes to a nursing home. Annuities can be used as a spend down to preserve assets and income for the healthy spouse. So in this instance, that's what happened in this case. So Suzanne Bresloff went to a nursing home. In 2017, her husband Julius bought a pretty big annuity for $565,000, paying him $9,500 a month plus for 5 years. So basically over 5 years, the money comes back. Unfortunately, Julius died in April 2020. So there was still 2 or 3 years left of payments of this $9,500. And the question is, who does that go to? And MassHealth has required that the annuities say that payments, any payments after the community spouse's dies, if there's still payments coming in, go to MassHealth to the extent of total medical assistance paid. And I found that kind of confusing in a number of ways, because it could depend on timing, because at what point is total amount of medical assistance paid on Suzanne's behalf, on the nursing home spouse's behalf, on the date of the death of the previously healthy spouse, or does it keep accruing? But in case, the next beneficiary in this annuity was the daughter Jennifer, and she said MassHealth doesn't have the right to have this requirement, so it should be void, and the annuity payment should go to her, Jennifer. And the insurance company didn't know what to do, so it asked the court to decide. And we came into this case. And so again, Jennifer said, basically claimed under the federal rules, the MassHealth can't have this requirement. And there's a number of arguments for that. And the court holds against her. So it says that basically, if she were able to get the proceeds of the annuity, that would be tantamount to Julius having just given her the money. And since if Julius were to do that, it would have created a transfer penalty for Suzanne. She can't get around that by arguing that she should be the remainder beneficiary of this annuity. Now, what we have now is two contrary decisions, because decision we talked about last year in the Germany case, the court ruled the other way, and so it says it finds, I'm trying to read the language here, it finds that nothing in the plain terms of the contract suggests that the benefits paid language refers to anyone other than the annuitant, the community spouse. So basically, it's saying that basically the Medicaid rules, which say that the annuity must pay back for benefits paid, only refers to a situation where the community spouse, who's the annuitant, goes to a nursing home. Not that and I'm not thinking you're clear on this, but Julius died. If he had been in a nursing home, and he, in that case, the state would have been entitled to repayment if he'd been in a nursing home and covered by MassHealth. Of course, he was getting $9,500 a month, so it probably never would have happened. But if it was a smaller amount, he was getting MassHealth, then MassHealth could require that it be paid back. But the Germany case says they can't require that he pay back for his spouse in a nursing home. So anyways, we have conflicting decisions, and I'm sure this at some point we will have this resolved. And I'm afraid in this case it might be resolved in MassHealth's favor, but we'll see. So another MassHealth case, Guilfoyle, involves kind of I think another crazy argument by MassHealth, and it involves a life estate in a nominee trust. So in 1999, Dorothy Frank transferred her home to the Frank Family Realty Trust. In 2001, she created scheduled beneficiaries, and the scheduled beneficiaries said that she had a life interest in the trust, and at her death, the remainder interest would pass to her 5 children. In 2017, she moved to a nursing home, and MassHealth rejected her application, claiming that she had accountable asset, which was her interest in the home that was in the trust, and that rendered her ineligible. And we calculated that as $109,000. I assume that was the value of her life interest. And and as you may know, if you have a trust, a property in a revocable trust, that's accountable asset. And if you have a property in a life estate and just have a life interest, that's not accountable asset. That's your home, and as your personal residence, it's not accountable asset. But in this case, we have a nominee trust, and it's sort of neither fish nor fowl exactly. It's not a revocable trust, and it's not a life estate and a deed. And the SJC says, well, a nominee trust, and this often confuses people, even though it says it's a trust, it's really a principal agency relationship where the trustees manage the property for the benefit of the beneficiaries who are listed on the scheduled beneficiaries. And it says that upon the transfer of Ms. Frank's property to the trust, an immediate property interest vested. So the beneficiaries had their interest, and Ms. Frank, basically property interest vested in the trust. So it's no longer that Ms. Frank had a property interest. And it's not revocable, since it's not a revocable trust, since under the terms of these trusts, the agents, the trustees, act as instructed by the beneficiaries who are named on the schedule of beneficiaries, and that included Ms. Frank's children, who were remainder beneficiaries. So she couldn't make any changes without their agreeing to do so. And finally, because a life estate does not permit an individual to sell the home and distribute the proceeds, we conclude that the retention by an applicant of a life estate in his or her primary residence does render the actually, that was a typo. So it should say does not render the property accountable asset. But if you look at the decision, unless they've corrected it since then, it's missing the not, because otherwise it would reverse what they decided. But just a comment on nominee trust. I think I've always been uncomfortable with schedules of beneficiaries like the one in this case, where it says one person has a life interest and then it goes through remainder interest, because it's like it's creating more of a trust document, or it's not clear what that is. I think it's a lot cleaner, if you want to do this, is to create a life estate in the deed. And if you have a lot of children and you want to have a nominee, them hold their interest in a nominee trust, which you might want for a number of reasons, have in this case, Ms. Frank, have the life estate in the deed, have the remainder go to the nominee trust for the benefit of her daughters, and then have their interest laid out in that trust, and they should have a present interest in the remainder. I think would be a much cleaner way to do this, rather than having these complicated schedules of beneficiaries. So just my 2 cents. So the next case involves reformation of a special needs trust, Valerie R. Pesci Supplemental Needs Trust case. So as you may know, if you are creating a special needs trust for somebody else, in most cases, you will not have a payback provision in it, because it's a third-party trust, and you don't need to have a payback provision in it. And but if someone's creating a trust with their own money, then it's then it needs to be a D4A trust or D4C trust with a payback provision to MassHealth. But a lot of practitioners, unfortunately, were confused about this back in the day. And so this trust was created in 2001. Albert Pesci created it for his daughter Valerie. He put in $200,000 in it, and said it was a D4A trust. And again, there's no reason to have a D4A trust if it's a third-party trust like this, but it said it was a D4A trust, and it contained this payback provision. He died in 2007, and the rest of his estate went into the trust under his will. Valerie died in 2015, and at that point, the trustee sought to reform the trust to avoid the MassHealth payback because it said, well, we never needed it in the first place. So MassHealth opposed the reformation, saying that maybe Albert did intend to create a D4A trust and the reason he might have wanted to do that is so that he could qualify for MassHealth. Because if it's not a D4A trust and he transfers $200,000 into it, then he's ineligible for benefits himself for the following 5 years. But if it's a D4A trust or what's called a sole benefit trust for a disabled individuals under the age of 65, there's no transfer penalty. So they're saying, well, he did it on purpose. And the trustee responded that no, that couldn't have been the case because it wasn't that he just had $200,000. He had a lot more money, and so he wasn't going to get MassHealth in the next 5 years anyway. So there would have been no benefit to creating a trust that didn't incur the penalty period. And the court agreed with the probate court agreed with MassHealth, and the appeals court in this case comes up with a middle ground. It says, oh, well, maybe MassHealth was right with respect to the $200,000 initial funding, but the money that then went into the trust, and it's not clear from the decision how much went in when Dad died, when Albert died, but they say that the money that went in when he died is there's no way that would have anything. He couldn't have intended that to go in to a D4A trust so that he could get MassHealth himself. So they kind of split the baby in half. They said the first $200,000 will be subject to estate recovery, but the money that came from Albert's estate will not be subject to estate recovery. Of course, how they expected them to figure out which dollars were which, I don't know. But anyway, that was the decision. In the dissent, Judge Peter Rubin said this doesn't make sense because in order to avoid the MassHealth penalty period for funding the trust, it doesn't actually have to be a D4A trust. It has to be a so-called sole benefit trust, solely for the benefit of Valerie. And the D4A trust qualifies, but you can also have another trust for Valerie that says it's for Valerie's benefit and that her death is payable to her estate. So there's no other beneficiaries. It's only for her benefit. Also qualifies. Now you may say, well, what's the difference? A D4A trust has a payback provision, but if Valerie has assets in her estate, they're going to be subject to estate recovery anyway. And the difference is basically the extent of the estate recovery. So a D4A trust subjects the assets in the trust to MassHealth payback for benefits paid, for any benefits MassHealth paid. A estate recovery may only recover against benefits paid after age 55. So again, I don't know Valerie's age or how much was spent, but maybe that makes a difference. Or maybe it's just lawyers and judges arguing over fine points of the law that don't make such a difference. So that's, if you have a third-party trust with a payback provision, you may want to reform it early rather than late, I guess is maybe the conclusion here. So we're at 12:45, so I'm going to skip over these two cases that are actually I had in here and go to one last case. These cases were both out of state and a little bit older. They're interesting because they both One addresses the questions of what does grandchild mean in a trust, and the other addresses the question of what does spouse mean in a trust. But they're both very fact specific. But this is a Massachusetts case, which I think the last case here, which I think is important to review, and that is guardianship of AR. And as you probably know, if you are under guardianship and you need antipsychotic medications, there's a whole process for getting court approval for those medications called a Rogers proceeding. And at the Rogers hearing, the proponents of the medication plan have to answer a whole lot of questions about why this is the right thing to do. And the ultimate decision is supposed to be a subjective decision. It's supposed to be the judge has to say if the individual under guardianship were able to make the decision himself or herself, knowing all the facts and all the factors, what would he or she decide to do? And in this case, the person under guardianship challenged the medical order with respect to one drug, and so ultimately went to the appeals court, and the appeals court basically agrees with him. So first question is, in order to get guardianship, you have to have a medical certificate signed by a doctor saying that you're incapacitated, and in this case for mental illness. And the question is that medical certificate admissible as evidence of your mental illness? And the appeals court here holds it is not. So it says it's necessary to initiate the proceeding, but it's not admissible as evidence. Though they quibble a bit, they said if no one objects, basically it is admissible evidence as to the need for guardianship. But if it's challenged, it's not admissible, and you're going to have to get the judge on the stand. Now, in this case, the judge was on the stand, and then the treatment plan must be based on a subjective standard. And in this case, the AR accepted one drug and wasn't challenging it. He didn't like this other drug because it made him dizzy, and the court found that quite relevant. So he was not making an unreasoned decision. He was not saying that he doesn't need treatment, not saying that he doesn't need drugs or no drugs are good. It's just this particular drug he didn't want. So here the admissible evidence tended to establish that AR had the present capacity, and then quoting the court, to weigh the risks and benefits of certain medications and to make informed treatment decisions related thereto. This is underscored by AR's choice to refuse Invega Sustenna because of its side effects while simultaneously voluntarily taking Prolixin. In sum, Dr. Goodman's testimony alone was insufficient to meet the department's burden. So basically they rejected the treatment plan, and it's an interesting case because in some ways it was moot, because by the time this got to the appeals court, the treatment plan had already expired, but the court felt that it needed to address this because that would recur in lots of cases. It did say that if AR's situation changed and he needed treatment again or was no longer willing to take Prolixin, which was necessary, the Department of Mental Health could always come back to court. But I think that probably one of the most significant findings here is that the medical certificate itself is not evidence that may be admitted as to determine either guardianship or the need for a Rogers determination. And that's all I've got today. If you went through a lot pretty quickly, and I think some of the cases I explained better than others. All these cases were written up on the blog on our site, margolisbloom.com. So you can look at longer descriptions there. And feel free to, if you have any questions or need to contact us, feel free to send an email. The firm email is firm@margolisbloom.com. If you'd like to comment on anything or send me a question individually, you can send it to me at hsm@margolisbloom.com. Thank you for your attention.
Thank you. Thank you, Harry, so much. And we will send out a recording when it's available. So it usually takes about a week for me to turn everything around. And thanks again. Hope everyone has a great day.